tunajaribu bora uko na answer, kama hata una pia na research on my feet. You can start, Mr. Chedwick.
Okay, but I should ask a question.
Yes, oral questions that you have from your end.
Okay. The question that I want to ask: differentiate between subdivision and partition. That's the first question. Yes, Martin, you have raised your hand. Maybe you can answer that. Subdivision and partition.
I'm actually trying to pull this book. Anyway, I was in my best. But anyway, what is the question again? Actually, the difference between what and what? Subdivision
and partition.
Or partition, a partition. Partition, subdivision. Now, of course, this is in conveyancing, and subdivision is where you get a property that parties have bought it together, and they need to be able to get their individual allocation. So they have am I clear? Subdivision, partition. It's sounding so close. I know there's one that they have a common title, so they subdivide the parcel. So there's that joint ownership into that. Partition, I'm not too sure, but partition, of course, is where you get the entire piece of land, then you allocate the fraction of what it is that you own in terms of the acreage. So you get your own sectional title of that partition that you own. I don't know whether I'm right or wrong. Correct me.
I can also try. Surprisingly, ni kitu tumediscuss leo in conveyancing procedures, and it is clear that when it comes to subdivision, you are interested in making one parcel of land to produce two parcels. But for partition, it applies where the land is owned by more or one person and the co-owners want to separate their undivided interest.
Yes, that's very correct.
Come back again, sorry.
For subdivision, you are focusing on making one parcel of land to produce two or more pieces of land. But for partition, it is where the co-owners, tenancy in common people, want to establish their undivided shares so that they can have a defined number of shares and each will have their own title, then they can now sell to third parties. Sawa. Chedwick, you can continue.
Yes, the second question. Identify at least 3 conveyancing practitioners or agents involved in conveyancing and their roles.
Architects, their role is to draft building plans. And Kinanold Mjaribu, land valuers, their role is to value a parcel of land, e.g. for compulsory acquisition of land.
Okay, I asked, identify at least 3 conveyancing practitioners or agents and their roles. So Victor was responding and he wanted to give the floor to others. He said
surveyors.
Yes.
They do the subdivision or partitioning of the land.
Then the lawyer advocates, we helped for the develop purchaser. Then the land valuers. Then the land registrars for attestation of the final title. Yeah. Victor has enveloped. Okay. Yes, anybody else?
Estate agents, these are brokers.
We've said surveyors, architects.
Physical planner who are who are involved in the change of views. We have also socio-economists who do the environmental impact assessment for sectoral property. We also have
quantity surveyors.
The quantity surveyor would do the bill of quantities. We have the contractor who does the contraction. I don't know whether they are part of them.
Who does the this we have valuers who value the value of the land.
Yeah.
So on the same note, we know that the law of conveyancing requires that all agreement or like all transaction should be expressly written. But there are instances where it is not expressly written. It doesn't follow Section 33 of the Contract Act and Section 38 of the LRA. So, which are these instances when a transaction in land can proceed without being in writing?
Tebu come again. Kuna exceptions?
Yes, there are exception when the transaction in sale of land can proceed without being in writing.
Are you sure?
Yes.
A transaction of land without unless
auctioneer akitaka kuuza shamba.
No, but you see that is auctioneer. You know
those are alternative forms of obtaining title to land without entering into a normal transfer process. Ndio, Mr. Chedwick?
Yes, that's what I meant.
So auctioneer kuna ingine ama ni auctioneer peke yake?
Adverse possession.
Yes, adverse possession. Ziko
Compulsory acquisition.
Wadera alifunza hizi vitu. When a transaction in land can proceed without following hizo procedures are
okay.
So assume umeuliza kwa oral sisi waswali. But is it not what akili yake? Say it because the answer. I'm just asking because it's better to kinani hivi. Also when we write them, at least hata ukinini, because I also realize hata ni vitu zenye unaona zile vitu tu umesoma that unakumbuka mwalimu akitaja but you just want to ni way of revising as well. So ndo maana. But let me also check but kuna hiyo yenye auctioneer anaweza uza shamba and hiyo process yote isifuatwe. Completion ni
Okay, that sounds interesting. So let me ask a question. Are we still on orals? Can I ask a question?
Yes, we are still on orals.
So I'm going to ask you a question.
Okay.
I think let's first to exhaust your nini and then you can proceed.
Sorry, I
But
got
you
you.
answer ya nini instance yenye sale of land inaweza proceed without following hizo procedure.
Well, you have statutory power of sale. We have adverse possession, sale by auction venye umesema. Kuna nani nyingine?
Compulsory acquisition.
Kuna compulsory acquisition. Kuna nimepotea. Is prescription the same with adverse possession? No, so no, prescription ni more than 20 years. Prescription ni different na adverse possession.
Ni different because prescription ni ile instant yenye tuseme people are using people wamecreate barabara kwa shamba yako and have used it for more than tuseme like 20 years na hiyo ujai so hiyo ndo itaform part of prescription, like itakuwa tu kama ni sasa barabara. Huwezi kuja kusema that no, this is not my hapa si barabara ni no, such thing. I think from my understanding of that concept. And condition, it has to be more than 20 years. Like 20 years.
Just to be more than 20 years. You I remember. Then another way of acquiring land parcel through a settlement scheme, a government settlement scheme. Lakini yes, bado itakuwa compulsory acquisition through allocation from the government. Hapa zimenipotea. Nani Mr. Chidix zimenipotea.
I think tumezi exhaust. Martin, you can proceed.
Prescription is acquiring the use right of a parcel of land venye umesema can be created through easements hizo vitu, but on the other hand adverse possession is acquiring title over that parcel of land or interest. Ingine ni use right, ingine interest over the land parcel of land, beneficial interest. Yeah. Mr. Martin, you had a question?
Sorry, I went to the kitchen to grab something. Now, I wanted to ask a question. I don't know who to ask, but all the same. Can you give me the procedure for granting letters of administration?
Yes, I can try it out. You first obtain a chief's letter identifying the various beneficiaries of a deceased person. Then you move the court. Yes?
Unaenda polepole kidogo ndio ninaandika.
Kwani unaandika na natoa kwa kichwa?
Unasema tu ndio naandika.
Okay, sawa. So you move, you first take instructions as an advocate, alafu ukipewa instructions by the client, you go together with the beneficiaries to a chief's office of the jurisdiction of that domicility of the deceased person. You obtain a chief's letter. It is that chief's letter that will attach in various application documents, and you will approach court through a petition because the letters of administration. After petitioning the court will grant orders that this that you gazette this matter. After gazetting, the estate of the deceased person you will have to wait for a period of 60 days for you to come back and confirm a grant. Okay, kwani kuna kitu naruka, kuna 30 days mahali.
Kuna 30 days to allow
the petition,
mtu
the gazettement,
object. If
a notice will be published in the Kenya Gazette, alafu inviting objections within a period of not less than 30 days. So hiyo 30 days inalai venye duration ya gazettement imehappen. So umegazette alafu unapeana 30 days to allow objections. If no objections are received, sasa ndio utagoja expiry of 60 days. Okay, relax. So usha gazette the state, umegazette. Una gazette nini? Una gazette grant ama una gazette nini?
I think you gazette the intention, like to nani.
Yes.
Even before you go to the gazettement, I think there are a few things you have omitted in there. Because number one, you're seeking the grant of writers of administration of the deceased estate, right?
Okay.
So after you get the letter from the chief, or the petition, what are you supposed to accompany on the petition so that it can be given, so that you can be able to get the grant and all that? Yeah. Number one, remember you have to be able to go and on your petition you have to do supporting affidavit that is going to introduce this other document you need to attach. One of them being the consent from the other beneficiaries that we don't contest, you being the administrator. Then number two, you also have to be able to get on that supporting affidavit. You have to be able to give the grounds where you need to be the supporting you as the affidavit, and that's why you need to have a surety. Yeah. So people who are going to come and say, I know this person, and he can be able to represent, and those sureties, and also they have to be able to they have to give us security. So in the event that you intermeddle or you mismanage, then there is a recourse. And also these people are also vouching in a way on for you as an administrator, that you are responsible enough to be able to administer that property of the deceased. So that I felt you have omitted. Yeah. So I think those documents that you need, because without the consent of the other beneficiary, of course, those are going to be the first objection they are going to give, to be able to give. So you have to be able to get a consent. Then also you have to have the personal sureties who are going to come and say, by the way, we know Victor, we know Chedrick, and he's going to be able to administer this property correctly. I think there are two sureties that you have to be able to, personal sureties, and then you have to be able to put they have to be able to put a security. They say, fine, we know his character, and we are going to put an X amount of money to it. And then now the court will be able now to go and look at that application and now be able to make a determination. If they feel that you know they're satisfied, then now they'll be able to, the deputy registrar will now be able to put a gazette notice, and also in the daily papers for 30 days, so that if there is any objection, then now the objection can be registered to court, halting that now process until now the objection is heard before the full grants can be confirmed within the 6 months. So I believe that could be the process, but let's see as you progress on.
So I avoided deliberately to go into the drafting aspect, but now here another question arose in the JSC interviews. What is the rationale of having guarantors in succession matters? Is it a must we have guarantors? What happens when my petition does not have guarantors?
I think
Yes.
I think for CLE, It is good practice. Ideally, the way I want to be able to look at it, who is an administrator? Remember, we have, if you go to the section 66, that probably can be able to give the administrators that you need to be able to have, all the way from the spouse to the children to So you need now to be sure. You need to be sure who. I think the only guarantee that these people do, I think it's just a safeguard, that you're not going to meddle with the estate. So you're going to actually the benefit. It's just a security.
I also saw the justification that was where minors are involved, whether being beneficiaries. That's why you have to attach sureties and guarantees, because it is in their interest that you are representing. So after you have obtained this grant, you will have to confirm the same after the expiry of 6 months, as Martin guidance. So I believe from my end niko na a hazy procedure of the same. Juu kwa ground kuna tu vitu unafanya unapata umecombine 2 steps into one for you to fast track a matter, unless sasa Mr. Martin you have, or what you have told us is the full and final procedure for the same.
For CLE.
Oh, for CLE, nice.
For CLE, I think for CLE purposes, you have to ensure that you do those systematic. You do the attachment of all the required documentation. Then now you have the gazettement and the 2 daily papers of wide circulation. Then if there is any objector, if there is no objector, if there is an objector, then you go for hearing, determine what are the interests and what you need to be able to do to get to enjoin them or not. Yeah, making reference to section 66, yes, and so on and so forth. Then the 6 months now comes in. I think that's why they have that 6 months period. So that if there is any objection, it can be dealt with, so that before the grants can be confirmed.
Thank you so much, Mr. Martin.
Chadwick, you can confirm that, Chadwick?
Arnold.
For me nimesikia mko okay, acha Chedia clarify, ndo for me nimesikia mko kwa nini succession, nikasema kuna kaswali kingine hapo nilikuwa nakuuliza tu. Chedia, tumalizie clarify.
I think when tu nani Martin amesema it's correct. When tu amesema that kuna hiyo the procedure that has to be followed, so the 30 days ni any objector could raise any objection against the nini your grant, and then something in nani Martin I think forgot to add ni kuna wale like lakini priority, kuna kitu ya priority hapo kwa nini, where the wife inafaa ikwe in that priority basis.
Is it the one that comes under that section 66?
Oh, hiyo ya kunini ya grant nini?
The priority, yes, it comes under section 66. So that you start with the spouse, then you go with the children.
Yeah, so ndo nini basically to venye had I think hiyo tu ndo kitu I think maybe common, but everything is correct. Maybe this petition under what form inafaa go from gani? Maybe that's something in opinion za nini form 80 na
yes,
your supporting affidavit ni ile for form 19 ama ni gani ya probate and administration rules.
I'm yet to familiarize so much. Kuna 19, kuna 5, kuna 57.
from 80, then kuna hiyo supporting affidavit inafaa kwa P&A form. Ni form 17 ama form 18, one of them up.
Prescribed form zinanichanganya.
Ngoja nicheke.
You can't say prescribed forms. Chadwick.
You can use prescribed forms.
Hizi za forms. Yeah.
But ukiambia Odera hizo form atabambika sana kupee marks.
I tell you.
Like ni ile tu unashine na nini against the rest juu unaweza assume kama kila mtu akuja aseme prescribed form, so maybe like akuseti na kuulize which exact form, assuming client anataka nini
I totally agree.
True. Nimeangalia pia the breakdown briefly. Is the step number 1 you confirm death and obtain a death certificate. Sasa una assume sasa amefariki huko, umeanzia sasa akiwa amefariki. You identify the estate property. Then you identify the beneficiaries and dependents. You decide who will apply among those dependents. Then you decide on the number of administrators of that land. Then you obtain consents from other beneficiaries. Then you prepare the petition documents as you have correctly put it. Then you file the petition in court. You confirm the jurisdiction of the courts. Then you file in the correct court, because ujui kama pia panel on expect kusikia about jurisdiction issues. Then after filing, the court will cause the petition to be advertised in the Kenya Gazette, and the usual objection period is 30 days from publication. Upon the lapse of objection period, the matter will proceed to issuance of a grant.
Victor,
With no objection. Yes?
30 days or 60 days? Kama ni mimi niliona vibaya.
The usual objection period is 30 days from publication.
Okay.
So kuna gazette notice, unagoja for 30 days. 30 days ikiisha, the court may have to hear and determine the dispute before issuing the grant if there is an objection that has been filed. Kama hakuna objection, the court will proceed to issue a grant. Unaona? The issuance of grant of letters of administration occurs if there is no objection, and the court issues a grant of letters of administration. However, you should wait for 6 months, then you apply for confirmation of grant, and upon applying for confirmation of grant, the court will confirm the grant and issue you a certificate of confirmation of grant. This certificate states how the estate is to be distributed. Then we have another step known as transmission and distribution. After confirmation, the administrators will use the confirmed grant to transfer estate assets to beneficiaries. Then lastly, we have, that's it. Ukisha distribute ni hivyo, usha play your role. You can account back to court as the final step. Up to that point, I believe sasa your process ya nini imeisha. What's the difference between active voice and passive voice? What is the difference between active voice and passive voice? Yes?
Personal ya succession before.
Okay.
Yeah. So, okay, your client, okay, not your client, family of John, who died semi-intestate, he had left no children, no surviving child, no surviving spouse, and he died intestate. So the family of John approaches, as in you advise them on the way forward for the succession of the property John left behind. Okay, he died intestate, no surviving child, no surviving spouse. But father to John is still alive. Brother to John is still alive. Okay, mother to John is still alive. He had 3 brothers. One passed, but 2 are surviving. Okay, he had 1 sister who passed. Okay, yeah, that's my analogy. You can go ahead.
By that, you are testing on priority, on the order of priority, person to consanguinity. And I'll assume that I've followed the above procedures: confirmation of death, confirmation of beneficiaries, and you have correctly identified the same. Now you are at identification of administrators, and I'll make the parent to be one of the administrator. Because I'm only limited to 4, the siblings can also be co-administrators of the parcel of land. And then I will follow the procedure imekuwa laid out, but now under the intestacy provisions, and in specific, because ana spouse ana mtoto, anaingia kwa, sikumbuki the exact provision, but there is a certain element that there is a certain section that I will place this deceased person's estate, and then the same I will propose when it comes to the beneficiaries in order of consanguinity, in order of priority, and where a son amefariki akaacha wazazi na ana watoto, mali inaenda kwa wazazi, then siblings, in that order. Wazazi wanakuja on the upper side, then siblings. Then I'll also merge with the other criteria yenye ime clarify above. Will that suffice, Mr. Arnold? Yes, Mr. Chedwick?
Also, how to object to the confirmation of grant, maybe we need the procedure to object.
Okay, so that is on section 39 of law, succession, where you follow the order of priority.
True.
Yeah. Where the father and the first and for the main administrator, he is surviving. So in our case, the father is surviving. So not for the main administrator. So, but if the father is deceased, the mother, if both the mother and the father are deceased, we go to the brothers and sisters and their children in equal shares. Then, if none, we go to half brothers and half sisters. If none goes also on other blood relatives, the 6th degree of consanguinity. So, the father and the first priority. Yeah.
So,
if umekufa intestate na hujaacha any surviving spouse or children, so the father ndio atakuwa the nini. Hiyo ni section 39 of the nini of law of succession. The father ndio anafaa kuobeta kwa kwanza. If you call the mother, if anaenda tu na degree of priority up to the 6th degree of consanguinity. Ule unatafuta kuna yule kazini wako huko mbali sana. Ile vitu kayo. Yeah. Then JD.
Yes, nakusikia.
Okay, then upatane na Wakimani ya kuulize, hebu elaborate for me about the nini NIF, National Infrastructure Fund. The bill, the 2026 bill, the 2026 bill, the National Infrastructure Funds, is the 2026 bill. The bad one.
Okay, so basically the fund, the National Infrastructure Fund was, its main purpose was to fund government projects without borrowing from external sources. And something I wanted to add is that it has a board governing its how it operates, and it's chaired by the cabinet secretary. The CS John Mbadi is the cabinet secretary for treasury. So basically, that's what I know. And
Yeah, no, Joe.
Currently, Mr. Chudi, it does not have a board.
Yeah.
there's one that was appointed. CS John Mbadi had appointed some members. Let me just Google it and.
That is a council member. Honorable Bandi is the chairman of a council. It is currently chaired by a council. It does not have a board, and that's why ilikuwa inaleta issues on constitutionality. Is it a constitutional fund to begin with? And there is an act in imepea power, National Infrastructure Fund Act. So that's how you will have to
Definitely the CS Nini Finance ndio atakuwa the CS Finance ndio atakuwa the chair of Nini. So then unajua hapo ndo the another question itakuja through sasa connect with the Safaricom. So after nini Safaricom wame okay, after the government imeuzia the Vodacom sijui the shares, hiyo pesa inafaa kuja kwa NIF if I'm correct, inafaa kuja kwa
yes.
So hiyo swali inashindwa kuiconnect, but the issue of nini national nini infrastructure fund na Safaricom lazima zikuwe kwa oros. So we need to define the research on the Safaricom. Safaricom naielewa, but ya national connect lazima nikae chini nifanye the research on the national year fund and the connection, because the fund, the board was created as in to be loading money that the government maybe obtain or gain from selling or disposing some of it public or privatizing some of it institutions, so that money can be used to do development, maybe the improvement of airports, the roads, maintenance, something like that, but it was more infrastructures. So okay, Teddy, go ahead.
Okay, like nini, I think swali yenye unaweza hata uliza about that ni maybe you state maybe tuseme 6 bills zenye zimekuwa passed by parliament, but something yenye nimenote pia, it's also kuna sovereign wealth fund na national infrastructure fund. Maybe if you can be asked differentiate between the two, sovereign wealth fund na national infrastructure fund.
I can attempt to connect the three. Now, and the genesis of all this is the Privatization Act. Now, and what brought that about is the fact that the government, this borrowing has gotten to a point where it is not sustainable. So the government is trying to be able to pursue other ways that it can be able to continue funding development using the internal resources. So And that is what now brought about the Privatization Act. And in there is a privatization authority which is supposed to privatize various government entities, some of which are not profitable, and so on and so forth. And the funds that are supposed to come from those privatization initiatives are supposed to be put into the National Infrastructure Fund. The purpose of the National Infrastructure Fund is to be able to fund key investment development projects in the country, like the roads, dams, and all those mega projects. Yeah. Then number two, the sale of Safaricom, the funds have been channeled into the National Infrastructure Fund. Ideally, all the money for the government is supposed to be held in the consolidated fund, but to be able to have to bring that demarcation, then this National Investment Fund was created for that purpose. So the money that is put in that bucket is purely for development. So in the sale, the money from the sale of Safaricom are supposed to be, if not, they are supposed to be in that account of National Investment Fund. Now, how it came about, it was supposed to be, it's a privatization of the sort, because the government was sold its stake to Vodacom as a negotiated block. It was supposed to be handled by the privatization authority. But because of the politics as they are today, the National Treasury did a session paper that went through the cabinet, then it was discussed in Parliament, and that's, if you remember the time when they were talking about, Didi Nyoro was saying, we are seeing the goose that says that lays the golden egg, and so on and so forth. So it was debated. So it was like a shortcut. They did a fast track to be able to sell off Safaricom stake. Ideally, if you look at the Privatization Act, is a process which is supposed to take about 4 years, because you need to identify value and get, you attract suitors who can be able to give you more value, and so on and so forth. The acquisition and takeover that you're talking about. So in a nutshell, that's what happened. So now come to the wealth fund. So the wealth fund, it's a wealth creation fund. Ideally, what it's supposed to, if you look, it's now more futuristic. So it's supposed to be able to have a fund that it's just like a saving, more or less. It's a saving vehicle for the government, yeah. So that you put this money into this wealth creation fund, where it's attracting investment. And that's why they were saying, if you look at the some of the policy changes the government is undertaking in the financial services market industry, all the way starting from the cooperative amendment bill that is going on, just to be able to create some of those channels. So it's basically this wealth creation fund is just basically like an investment where you putting money in there. And that's why if you look at when the bill was being signed, they brought in kids, saying that this money is yours. It's not for this current generation, it's for your generation, so that you can be able to use it. So it's more or less like a saving vehicle as far as I'm concerned. Thank you.
Today, Victor, if you notice,
Yes.
we have always been concentrating with the Safaricom, Vodacom issue, but we have never talked about the mini pipeline, the Kenya pipeline. But then, see,
all that money has gone now to the National Infrastructure Fund.
I've
So
said
any
you
other
have never you have gone through the structure, the way the Safaricom Vodacom was done. It is merger acquisition where they got 50%, but you have never researched on Kenya Pipeline.
Maybe Mr. Arnold, you brief us on Kenya Pipeline, if you are aware of the fact.
Okay, I'm not really there with it, so Tatangatanga, maybe we make it an assignment. Then tomorrow, the first day, we go through the part that you have not clarified. We have not clarified. Instead of
Okay.
gentlemen, KPC was an IPO. You know, Safaricom was already listed in the stock exchange, but for KPC, it had never been listed in the stock exchange. So it was just floating its shares to the public.
You see, in Bogwa, when they started the issue of privatizing it, they started they listed it. They listed it.
Yes.
I even remember, they even gave the deadline. They even give the Kenyans the deadline to purchase
because you see what happens. Look at it from this perspective. This is a public entity. Who are the owners of this public entity? Who are the directors? You find, like if you go to any of these public institutions, look at the board composition. You'll find it is the government that owns this institution 100%, right? So what the government has done is to cede off part of the shares. Remember we were talking about the shares transfer and all those kind of things. So what the government has done is to come and say, when you say I'm privatizing, is that I'm converting this public institution into, I'm diluting my shares literally. So what they've done is to cede off. It's just like the Safaricom thing, only that Safaricom was already publicly trading. If like Kenya Power today, is trading in the NSE market. Kenya Power is trading in the NSE market. So if at all any buyer was to come and buy the controlling share, then that would be a different thing altogether. Or if the government was to come and say I'm ceding, but for KPC, they had never traded, so that's why it's called an IPO, initial public offer for people to come and buy shares. And because the shares, I think they manipulate the books of. I'm not too sure, by the way. Now that this is going to the internet, I retract that one.
That is all captured.
I don't know, but you see, that's where the government of Uganda had a lot of interest, and they bought in quite a huge chunk. And we have the public, you and me, and everybody else went and bought the shares and all that. So it was an IPO, purely an IPO.
Okay, so Gogwa, what you want to know? I can say you got an idea of about it. So you can tell, you can do some research. Then tomorrow you tell us more about the Ugandan part, because there's a question I had someone asking. Currently, even if you ask me, I can't tell you the shares in the Ugandan government.
No, they bought quite a. I don't know how much stake they bought, but the government of Uganda bought quite a huge chunk. But also remember, some of these things are so deliberate. You know why? Because look at it from this point: Kenya Pipeline. Then you have Dangote, who is coming to invest in the refinery. So when you refine this oil, where is it going to go? It has to go through the pipeline, isn't it? So some of these things, as much as probably it could not have made a lot of sense to the Kenyan at that point in time, then again now you start seeing, some of these guys, they see far. Because it's government, he's able to see very far. And I believe that's why even our president went to TZ to tell them, you know what, can we have the refinery constructed here? And I think he was just only trying to be able to, he knew that Dangote was going to come and invest. But you see, if you look at, I think, if you look at Uganda again, they have constructed a a pipeline of about 445 kilometers passing through Tanganyika, and is going to be completed in July, going to the port of, is it Dar es Salaam or someplace? So if you look at it, there is a lot of geopolitics realignment that are happening, that Uganda wants to be able to ensure that it's able to put all its eggs in, it doesn't want to put all its eggs in one basket, so it wants to spread its risks. So it's very strategic. So people thinking that Museveni was just coerced into buying the shares, no, but the government of Uganda knows what to do, if you had to ask me, in that transaction. Anyway, but I believe that is but for KPC, it's very, indeed, it is an IPO. It was an IPO. It has never, KPC had never traded again in the stock exchange. Otherwise, you will not have had that issue again. Thank you.
Mr. Martin, you are well advanced to that sector. Unless Mr. Arnold, you have another question, because I have two questions that can also confuse you.
Okay, go ahead.
Yes, I'm borrowing from Chadwick's question on revocation. So there are some documents that one is supposed to file. I want you to tell me when you will file these documents. We have an affidavit of protest, we have an objection to making of grant, and we have application for revocation or annulment of grant. Those are the three documents that I want you to tell me at what time or situation will you have to replying using those documents when it comes to the probate and administration procedures. Where will you use an affidavit of protest? I'm asking, where will you use an affidavit of protest? Where will you use an objection to making of grant? And where will you use application for revocation? Mnapata my question mzuri, because for you to be in a position to answer this question, automatically you should have noted the various points where an objector can raise an objection. Now ni kama basically nakuuliza, when an objector wants to make an objection, there are some documents provided in by the law of the probator. Yes, Mr. Martin.
I could attempt. I think maybe I'll start with the protest. I think you do a protest when, for example, you find the administrator or the representative has probably left out some properties that were supposed to be in the list of the distribution, or probably the distribution was not well distributed, was not well administered. Maybe probably there could be somebody who has not been provided for. Then the objection is where you're objecting the administrator himself, the entire administration process. So where you're saying, which is very fundamental. So, for example, you have this administrator who has been given the grants, and you want to object them getting that administration, like we saw in the case of this case that was just decided the other day of this lady from Tanzania. And then also, if you are to talk about, we've talked about the protest, then we've talked about the revocation. So the revocation will happen when either the grant that was confirmed, probably it was confirmed, and the court finds that it was there was some fraud that happened for it to be granted. So I think in that case, then the court will go ahead and revoke that grant. So, and probably if probably there's there is probably a court order that probably could have halted that process or that grant in as far as it's concerned. That's my thought.
Mr. Martin, umepata mark moja. Sasa there are various situations that I want you to master. When a petition has been gazetted but grant has not yet issued, and you are the objector, you approach court via an objection to making of grant, because you are objecting for the grant not to be issued. Where the grant has been issued and the administrator is applying for confirmation, but the grant is not yet to be confirmed, you approach court with you using an affidavit of protest. Lastly is where you have correctly captured the same. The grant has already been issued or confirmed and you want it to be cancelled. This is where you approach court pursuant to section 76 seeking application for revocation or annulment of grant. So up to that point we have clarified the three common situations that usually confuse students when it comes to the procedure and how you can object. And what are the common grounds of objection? You have tried to mention some. The petitioner has excluded some beneficiaries. The petitioner is not the right person to administer the estate. The petitioner has concealed material facts. The deceased had another spouse. The alleged will is invalid. The estate property has been misdescribed or omitted. The petitioner is intermeddling with the estate. The petitioner is hostile to other beneficiaries. The deceased did not die intestate. The petitioner lacks priority under the Law of Succession Act. Then we have what we call an answer to petition. After an objection is lodged, the court may require the objector to file an answer to the petition. The answer responds to the original petition and explains why petition should not proceed as filed. For example, the answer to the petition may state that the petitioner is not the only widow, the petitioner has omitted some children, the deceased left a valid will, the property listed is incomplete, the petitioner is not trustworthy. Then you file a cross application if you want to be appointed. If the objector wants to be appointed as the administrator, either alone or jointly, the objector should file a cross application or petition for grant. This is important because merely objecting may stop or delay the original petition, but if you want the grant issued to you, you must ask the court for that relief. So those are the nitty-gritty zenye niliona. If you are approaching anything to do with probate na uchanganikiwe, itakuletea shida. So let us look at the procedural summary of what I was trying to tell you. You check for an objection before grant. Let's say grant is not yet to issue, because hapa ndo tumesema we do an objection to the making of grant. So you check the gazette notice. You file objection within the 30 days period in the gazette notice. Then you state your relationship. Then you file an answer to petition if required by the court. Then you file cross application if you want to be appointed as the administrator. Then you serve the petitioner and you attend court for directions. And the short answer that you can frame it is that an objection to letters of administration is filed after gazettement but before the grant is issued, normally within 30 days. This is where the objector files an objection, may file an answer and cross application, and they will serve the petitioner, and the court then hears the dispute and decides whether to issue the grant to the petitioner, the objector, or both jointly. That is the key takeaway. We have 3 documents before we go to the issuance of a grant. Before gazettement, but before the grant is issued. An objection, an answer to the petition, and a cross application because you want to be granted the power of an administrator. So those are the nitty-gritties. Yes, Mr. Martin.
So are you saying that after the gazettement, you have to object within 30 days? So what happens if I object after 30 days? I have to seek leave of court?
I believe you'll have to move to the second category because 30 days will have lapsed. And the second category, you will now be using an affidavit of protest. Because upon the lapse of 30 days, we are moving the court for letters of administration, and the letters will be issued. So let me see whether you can seek extension of time when you want to object out of the 30 days, whether you can seek leave from the court.
Well, I think you can. It cannot be what, because I can imagine, supposing it's somebody who is in the who has more priority, and they probably did not see that that gazette notice for whatever reason. So what happened in that case? I think why the 6 months? What is the purpose of this thing? 6 months.
Okay, yes, I've found your answer. Under section 68(1) of the Law of Succession Act, an objection should be lodged within the period stated in the Gazette notice or such longer period as the court may allow. And so the court has discretion to extend time for filing an objection. Under section 67(1) of the Law of Succession Act, a petition for grant must be gazetted and objections invited within a period of not less than 30 days. If 30 days have expired but grant has not yet been issued, you should file an application seeking leave to lodge an objection out of time. So what are the documents that you will usually file? You usually do a summons for extension of time, supported by a supporting affidavit explaining the delay, and you attach the draft of objection. You also attach the draft answer to petition and attach the draft cross application if you want to be appointed as an administrator. So the answer is yes, you can seek extension of time. But if the grant has already been issued, if the 30 days expired and the court has already issued the grant, filing a late objection may not be proper, because the better route is usually an application for revocation or annulment of grant under section 76 of the Law of Succession Act, if that grant had been obtained and went to confirmation part. But where there is no confirmation, we saw that we are approaching court using an affidavit of protest. If the grant has already been issued but not confirmed, this is why you file an affidavit of protest against confirmation. And you are allowed to say that the proposed shares are unfair, some beneficiaries are excluded, some properties are wrongly included or omitted, and one house or branch of the family is being favored. So this is the breakdown of what I am explaining. The breakdown is that if the Gazette notice is issued and 30 days have not expired, you file an objection within time. If the Gazette notice is issued and 30 days have expired, the grant is not yet issued, you apply for leave to object out of time. And if the grant has already been issued, you apply for revocation if the grant was issued and confirmed. You apply for revocation or annulment under section 76. If the grant is issued but is pending confirmation, you file an affidavit of protest to confirmation. If the grant has been confirmed and distribution done or ongoing, you seek revocation, review, or appeal, or other appropriate application depending on the facts of the case. So that's how you will approach that question. That's how you'll approach that question. Explain the difference between active and passive voice with at least one example in each. This is testing your knowledge on LWD. LWD, what's the difference between active voice and passive voice? Just a simple difference, provided you have an example. That is what will save you. I don't expect a lengthy answer to the same. Any attempt? Yes, Mr. Chedwick.
Okay, I would say passive is like form of recorded speech, while active is maybe like it's something that you are stating while it's actually happening.
A good attempt, but that is not the main one I'm looking for.
Okay. You are inactive. Inactive, you can say the subject matter is active, as in it does a certain action. The subject matter is in action. It is doing a certain action. But in passive, the action is being done to the subject. That's what I will say. As in the subject is used to the action.
A very good attempt, Mr. Arnold. You have correctly attempted.
Oh,
Mr. Martin?
I think I'll have put the action is what is ongoing, and passive is what has probably passed. So it's something that
No.
my English is not my English.
No. That's not the answer that I'm looking for. An active voice now side towards Arnold because the subject, not the subject matter, the subject of the sentence performs the action expressed on the verb. And a good example, Mr. Arnold Ujanpe example. The police officer arrested the man. In this situation, the subject is the police officer performing which action? An action to arrest another person. So that is the action. When it comes to person, yes, Mr. Arnold? Yes.
Like I said, maybe the chef baked the cake. The cake was baked by the cake. Okay, active for the cake. The chef baked the cake. That is active. Passive, for the opposite. The cake was baked. Cake is the subject. So, chef is the baking is the action. Single. The word bake is the action. So the chef baked the cake. So the chef did the cake is the subject which action was performed on it, which performs chef is chef is the subject who performs the action of baking. So the chef baked the cake. Then in the other cake, the cake was baked by the chef. As in?
So yes. Okay. You see, when you give us examples, inakuwa very clearly identifiable. So for members akina Martin and Chedwick, that is the correct interpretation of how you'll use an active voice and a passive voice. Now mostly inakuwa tested in LWD. Now I have another question. Why do we need... Yes.
You the cake taking itself, me, I didn't get it, to be honest with you. I'm not taking itself.
We explain, lakini umepata the concept, Mr. Martin.
Just repeat it once.
Ajua hapa kwa active action subject matter perform action. Can get you confused. the subject coactive, the subject matter inafanya action the nini, but kwa passive the subject matter receives the action. So ndo tumesema the chef baked the cake. So hapa our subject matter is the cake. It is receiving it in passive itakuwa the cake was baked by the chef. So the cake received the as in it's opposite. Something like that.
Mr. Arnold, where do you use passive voice?
Passive
What scenarios or circumstances makes you to use passive voice?
scenarios as in past tense.
Now, what will inform you that in this situation I need to use passive voice and in this situation I need to use active voice, but I'm only interested on the passive voice.
Okay, in passive
What are the circumstances?
the actions happened okay before the action okay as in before, not after. Passive is something okay, passive is something that has happened, it has already happened. That is passive. Something has already happened. Active is something that is currently active. Passive is dormant. But active is something in action side. That's what I can say.
Okay, thank you, Arnold, for that attempt, but you have circumstances where you use passive voice, where the subject is not known, where it is irrelevant to state the subject, where you want to hide the identity of the subject, where you are using reported speech, like sasa hiyo ndio umepata, and the action being emphasized rather than the doer. You want to emphasize more on the action as compared to who did that action. So I can repeat, where the subject is not known or it is relevant to state the subject, and we want to hide the identity of the subject, where it is reported speech, and where the action is the one being emphasized rather than the doer of that action. So those are the key takeaways from search. Now I also want to ask another question, unless Chedi pia uko na swali, so that we have a balance.
You can just proceed.
What is the purpose of evaluating a management development program? Say umepatana na lecturer wa LPM. Hizi unaweza pata kweli kama hujapitia hii unit. What is the main purpose of evaluating a management development program? The answer is to know whether it has achieved its objectives. Oh, management development program. Hii tumefanya, si niko kwa HR huko.
Hiyo topic hata yenyewe inachanganya mtu.
Acha niulize maswali mingi kutoka hapa. Mr. Martin?
I think I'll answer it from general knowledge. When you talk about management development program, it means you're looking at a program that is focused on developing the skills and competencies of the management so that they can be able to be effective in their roles. So the purpose of evaluation is to be able to see whether the program is it's going to be able to have an impact, a positive impact on to their general their general performance. So you're looking at, are they able to make decisions better? Are they able to lead better? Are they able to control better? Just looking at the management function as a whole. So that way I'll be able to look at it. Does it have impact? And if it has impact, then is it able to have that impact reflected on their performance, so that they're able to coach better, to mentor better, to create better relations among the staff and all that.
Thank you so much Mr. Martin. Naka unit tumeiangalia in a practical angle of which inakufanya inakuwa rahisi. Why is a job analysis useful in almost every phase of employee relations? Why is a job analysis useful in almost every phase of employee relations? Hii swali kama ujui job analysis ni nini upati?
At least for clarification, mwenye atatujibu tufanyie distinction between job analysis and job design. Kindly. Mwenye atatujibu.
I can attempt that as well.
Okay. The question is, why is job analysis useful in almost every phase of employee relations?
My understanding of a job analysis is just from the little meaning of the word itself. You're looking at the job and what the job does. So it actually just trying to be able to assess and investigate what the job does, how it's done, what's the workload, what are the reporting lines, how it's supported, and so on and so forth. So, and why it is important in every aspect of the employee, because it's through the job analysis that you're able to come and say what are the job specifications. So what you're calling the job design, yeah. So that now you can be able to say this job is designed for an accountant. That's what you call a job design, because for it to be designed for an accountant, then there are certain things that an accountant should be able to have. Number one, they need to have these qualifications. All right. Now, and remember, if you look at the accounting, if you look at a department called accounting, you have various decision-making levels. Yeah. So you'll have the manager who is at the top, who is supposed to make critical decisions. So he's supposed to make strategic decisions. He's supposed to make operational decisions at that level. So then you find that the competence that you require will dictate that then at that position, the job design of that position should have certain skills, certain qualifications, and certain experiences. Yeah? Then now, through that, then you're able to kind of connect it to who that position is supposed to be, who is reporting to that position. So then again, you look at it from that aspect. Yeah. So it's able to help in terms of the span of control, so that you're able to know in the hierarchy who is supposed to report to who, and how do they relate. Yeah? So I'll be able to look at it from that perspective, because it helps to create the job description. It helps to create the job design and the job specifications. So in the job description, you're able to say this role is supposed to do what, this role reports to who, and this is how this role relates and connects with the other roles within the organization, because from there you're able to come up with an organization structure. So in a nutshell, that is how it rates from A to Z. Because it is from there, then if you're recruiting, what are you recruiting? I'm recruiting a manager, so what do I need? Yeah, and what skills and competence do you require for that position? So you look at it from a wholesome. So yeah.
Thank you so much, Mr. Martin. And because Mr. Arnold wanted us to clarify at the end of the day, is that a job analysis is the process of studying a job to understand what it involves, as Mr. Martin has correctly captured it. So job analysis is tied to studying a job, while job design is the process of structuring or arranging a job to decide what duties, responsibilities, methods, relationships, and conditions the job should have. So in essence is that the job analysis asks you this question: what does this job currently require? And a job design asks, how should this job be structured? And once you are in a position to answer those questions, you will have answered what the examiner expects. Because for a job analysis, it identifies the duties and responsibilities, the tasks performed, the required skills, qualifications, experience, tools and equipment used, reporting relationship, working conditions, performance standards. While on the other hand, when it comes to job design, it decides on which tasks should be grouped together, how much authority the job holder should have, whether the job should be specialized or broad, whether work should be done individually or in teams, how work can be made efficient, safe, and motivating, how reporting lines should work, and whether tasks should be automated, rotated, or enriched. Okay, so that is how Mr. Martin has correctly put it or crossover to us, and we have seen directly how the same applies. Now another question still on LPM, because I realize this part is where many students will not be adequately equipped. How many CPD points does an advocate require in a given year? And if you answer for the advocate, how many CPD points does the human resource require for a given year?
You sure about that question? Wait, Victor, are you sure about that question?
I'm sure, I'm very sure.
For the advocate, you need about 5, a minimum of 5. And I think for HR, you also require about 5 as well. So
10. For HR, 10, advocate 5.
Okay, I thought. Okay.
Human resource.
Ni kumi
za HR.
Ni kumi.
What's the purpose?
Wajua wao HR yeye anaenda tuseme wanaendanga conferences sana. Na pa hiyo conference wanafaa kutafuta less 6 point. Then nini waende workshop labda 2-4. Then membership inaendanga kaa moja hivi, na presentation inakuwa kaa moja hivi. Mpaka 10 roughly minimum. Wanaenda mpaka more than minimum ni 10. Yeah.
Okay, I thought I knew that profession.
Give us 3 forms of sexual harassment in a job place. What are the 3 forms that can help one to say that this is one of the forms of sexual harassment in this organization? Yes, Mr. Martin?
Hey, did I have my hand up? But I think session. Okay, let's check it.
Yes, you can say.
Okay, first one, I know it's called quid something sexual harassment.
Quid pro quid.
Yeah, quid pro quid. The second one is same-sex relationship, like in terms of someone being harassed because of his sexual preferences. So the third one, I'm not really quite aware of the same.
So I'll clarify. Quid pro quid is where you are using your power as a manager or to your subordinate to do a coercion, to engage in sexual activity. Then we have sexual innuendos, where you can be speaking in a sexual manner, you can be watching pornography, you can be winking on a certain individual. Then we have direct sexual harassment. This is where we have inappropriate touching of an employee. So all these are forms that are provided under the Employment Act to form part of how you will define a sexual harassment. Yes, physical harassment occurs under the category of direct sexual harassment because you have inappropriate touching of an employee. Yeah. Okay. Give 5 reasons why an organization requires a recruitment and selection policy. Why do we need a recruitment and selection policy?
I can
So zingine zina okay, yes, you can try.
attempt. I think why you require recruitment policy is number one. When you're conducting recruitment, you want to make sure that you are able to attract the right skills and the right competencies. So it helps to guide and also to ensure that the recruitment process is fair. You have fair practices so that you don't discriminate. So when you have a policy, it's able to guide the whole process so that it's fair and transparent. And also, when you have a recruitment policy, then it also helps it actually helps in enhancing the employee engagement and involvement. In that, when it's clear how you recruit as a company, you don't just recruit haphazardly. Then, of course, you're able to retain your staff. You have better staff retention and engagement. In that, you're also able to manage your bill better. You don't just place people, and you have better HR planning and all that. And of course, it goes down to your bottom line. So I'll be able to look at it from that perspective, but of course, I'm sure you have quite a lot that you can say about it.
Thank you so much, Mr. Martin. And you have correctly captured about transparency in the hiring process. You provide consistency, you show credibility of the organization, you ensure you get the best persons on board, and you give the recruiters an idea of the values that are being sought or the values that are to be practiced by those recruiting. So those are the 5 reasons why an organization will require recruitment and selection policy. What is the difference between recruitment and selection? Any person?
For me, I can first go on selection. Selection is choosing the best. Choosing the best from the category. Recruitment is in recruitment, you must have an advertisement. Then after advertisement, you go in. Okay, you choose, not choosing, but sikia nikisahau inanitoka akili, hiyo wadi inapotea. Another person as the selection, but recruitment hiyo zio mimi mwenyewe zinanitoka.
Okay, so I think maybe if I can try, recruitment is the process of inviting applications for a specific job, and then selection is now choosing the best from a pool of qualified candidates. So like you pick the qualified for a particular job.
That is the answer, Mr. Chadwick. What are the 5 managerial functions of a HR manager in a law firm? 5 managerial functions of a HR manager in a law firm. Yes, Mr. Chadwick.
I think first is to check on the welfare of the employees, if I would say that, and secondly is to ensure that there's proper workflow in a farm and in terms of organization of a law firm and ensuring equipments are properly functioning, basically. And what else? Let me think of. I'll also add is to oversee the daily operation of the farm, and also to dispute resolution also as well. So that.
Thank you, Mr. Chebik, for that attempt. We have planning, we have organizing, where he's grouping people into functions and coordinating activities. We have directing, they act as guide and motivate people to accomplish programs or work. We have controlling, regulation of activities through evaluation of performance, and we have recruitment. Those are the 5 managerial functions of a HR manager in a law firm. They plan, they organize, they direct, they control, and they recruit. List various policies that a law firm requires. In open-ended, you can just cite various policies.
The HR manager does not report.
Oh, it's hata ana report pia, ana report to the boss.
I think the way I'm looking at it, those will be the function of a manager, just like any other manager. Because the managers, they direct, they control, they report.
Yes.
So if you look at the management function, it's just now probably just trinket to read HR. When you're reading through, that's what just came into my mind. You can come in.
That is the position. Mr. Martin. Hii kitu ni venye unaiapply sasa kwa your general knowledge ndio itakusaidia. Alafu nilikuwa nimeuliza various policies that a law firm needs to draft. What are the policies that a law firm should have in your view?
Okay, you can start now with the AI policy. Then the other one is, let's say,
Client confidentiality.
Yeah. Client confidentiality. Which other framework?
Sexual harassment policy.
Employment policy, social media policy, promotion policies.
On the same note, can we also discuss the difference between its standard policy and what? The three.
Gani hizo jamani, Mr. Chedwick?
Zinakwanga sijui standard policy and procedure, the difference between topic I think tu ya LPM. What is standard, what are policy, what are procedure, something like that.
Let me share my screen. Nimeanalyze the constantly.
Procedures ni venye vitu zinafanywa. Say every law firm iko na the way they draft their letters, pleadings, something like that. Then they have the way they do their, let's say, mambo ni sala lema procedure as they have their culture in that law firm, if I get it correct. Okay, Mbogwa, Martin.
No, I will say this. first of all, in terms of policies, if you look at all the key frameworks that you need to be able to have in any organization, like for example, if you go to a law firm, you have to have the recruitment policy, you have to have the ICT policy. You can imagine. You have to have customer relation policy, all those kind of things that the frameworks, sexual harassment policy, compensation, and all those kind of things, procurement. But now, when it comes to the procedures, procedures are basically what Arnold said. This actually gives you the step by step of what you need to be able to do in terms of the internal processes. But now, the policy is the guiding framework that, in as far as we are concerned, this is how we handle our fire. Like for example, for confidentiality or data protection, you can be able to say you can only be able to disclose to this level of information. So if you need further details of this file, then you need probably this level of clearance. This can only be given by this level. So that becomes your policy. So it becomes your guiding framework within which you're supposed to fall through. Yeah. So that's the way I'll be able to explain the standard operating procedures is how you do the day-to-day operations, the internal controls, but then the policy is now the guiding framework. More or less, you're supposed to be to ensure that your policies are working. Your content.
So mostly the procedural are mainly internal, as per your take.
They're all internal, by the way. The policy, the procedures are internal. But what I'm saying is that a procedure is telling you what to do. When you come to the office, you open you open this, you take this file to this person, blah blah blah. You see, it gives a step by step of what you need to be able to do. But when you talk about a policy is a guiding framework. Yeah? Like for example, when you process this file, for it before it goes to court, it's supposed to be reviewed by, who is supposed to sign. Who is supposed to sign the application? Policy, it has to be signed by the senior partner, not by the juniors. You get? So that is a policy. But the procedure is now how do you prepare that file?
That is well captured up. So basically, what can you say it is? Hii unit Harmony Oral inaweza kushika pabaya kama hujajipanga juu most probably people ignore to read this unit na iko na nitty gritties zenye zinaweza kuchanganya. This is the reason why yes
ama tutafute siku moja juu most of the next week tutakuwa na evening class, tutakuwa na classes na classes. Tutafute siku moja tupitie the consult lane, yani hiyo
LPM. Yes, that is very possible. Juni kuna mahali if you are keen, itachanganya. Kuna session nimefanya, if you are keen, nimefanya section ya LPM hii yote. Unaona yote nime project nimefanya kwa YouTube. Iko 4 hours.
Turudie tu tena.
Sasa tutarudia tu, bado ndo nitaielewa hata kabisa. Tutarudia alafu tuende mbio, but I wanted to do this juu kuna sessions za LPM zenye sija tafuta. Unaona training and development, career development and management, you will allow me to start from bottom going upwards. I have a reason. Because naenda ku approach orals. Kutoka juu mpaka katikati, huko kote nimeshika, but it is dangerous if I have not mastered topic 5, 6, 4, 3 naona pia sijafanya and 2. Unaona hapa kwa job analysis and design, hapo unaona sijaguza, but huku kwingine kote niko sawa. So to be also helping you, tutaanzia chini tukienda juu. That's what we will do. Si tufanye shughuli Monday.
Ndio wewe unafanya nini at least ni orodha za kwanza at least asijeni pia.
Yes, hivyo ndo ndafanya. Let us start from bottom going upwards. Tuweke Monday, is it viable ama ninge research on Monday? Unajua inatakanga research kitu. Ndio natumia sources. tuweke Tuesday. Aki Tuesday itakuwa benefit sana because Monday I'm expecting ambitious from court task nini. Wacha tuweke Tuesday. Monday itakuwa short notice. So Tuesday jioni from tuanze saa ngapi ndio tunaji kufanya kazi kubwa juu lazima tumalize by saa 2 juu mimi niende nichukue gari. Acha nifanye saa 2. Tumalize saa 2. Yani nasema I usually commute. Yani nasema nikianza tuanze 6 juu I'm expecting group works hapo 5 wata Twitter meeting. So tukianza 6 immediately kama hakuna classes Tuesday tuanze 6 all the way to 8 kama tu normal time ya classes. Alafu nichukue gari nifike home. Nikifika home ina depending pia na venye plot iko, saa zingine kunaweza kuwa na kelele, saa zingine kuko stable. So by the time na settle hizo kelele zote na figure a way to reduce the same. By the time na settle tuseme sasa tunaipiga hiyo usiku, tunaendelea sasa from where we had left. Ni saa ngapi? Saa tunafikanga saa 5. Hadi saa 5. So tutafikisha saa 5. So automatically that will mean tutakuwa tumetoka hapa na some lessons alafu tukaendelea nazo ikakuwa session 2 so that ikue sasa tumeface pia the substantive part of it. In fact watu wataanguka unit by the fact that theory yenyewe hujaelewa alafu unaongeza pale mahesabu that term. So this is the pressure yenye Chedwick alikuwa anajaribu kusema inakuanga in that term. Watu wengi wanadhaningi watasoma in that term vizuri. But unapata in that term kuna vitu sasa ndio walimu wanaweka zile substantive. LWD mnaanza kuambia about bill, amendment of a bill. Kwanza unatupa focus. Unaanza kuintroduce to various documents you're supposed to draft. Alafu unaambiwa sasa ingia bookkeeping, ingia reconciliation statements hizo zote. Sasa unapata student anapata burnout, akona 3 months, amefanya oral wa the last category, ametoka tu hivi orals, amebakisha 2 months to exam, anachizi. So hiyo ina contribute to the failure rate. But once we have been able to dissect the substantive parts in portions, unapata leo tumediscuss an act, kuna financial systems act bado tuja-analyze. So those are the elements zenye zinafanya hii kitu inakuwa more practical to us. So up to this point time imefika, it is 1:30 am. So we want ndachukua a nap, nifike nifue nini nichote maji hizo vitu. Halafu tutaresume saa 8 saa 9 huko saa 9 huko. Unajua Sunday pia unafaa kurelax wiki isikue uko na burnouts on Monday. Uangalie kama kuna compliance kama mimi. So I usually prefer Sunday tupige huko majioni 4-3 unataka kunyolewa. So tutaipiga huko majioni tu, bora tuna pressure juu itakuwa oral session continuation. So we'll proceed with our oral questions. Alafu pia in our oral questions pia nitaleta maswali mingi za LPM, trial advocacy, hizi units zenye watu wanaweza kuwa wanaignore. Alafu pia civil. Remember civil pia ni one of the unit yenye inatoa maswali mingi za orals. So tomorrow let us take that approach. LPM, trial, civil. LPM, trial, civil. Then matters arising in the discussion ya section 3.5. We read the brief facts, issues and holding, and we see the jurisprudence ilikuwa behind section 3.5 of the Law Succession Act, and that will be a proper cover up ya oral session tomorrow.
So tomorrow tuweke at least kesho masaa 2 jioni.
Sawa, that is possible. Wacha tuifanye saa 2 jioni. Mimi sipendi.
Hii imekuwa marathon.
Sio nimekwambia Sunday pia sitakangi mbio. Si umeona? Sunday sitakangi. Sunday ndio unapata energy.
Can I tell you something?
Yes.
We started in fact like because of hii mambo kwa mwaka 5 nimeamka.
Okay.
So you find your day, after me, I'm telling you, I think I'm having a burnout. But let's do it tomorrow. At least hata tulale kidogo, mtu apumzike kidogo, fresh kidogo.
Right, 8 iko sawa. So unaona hata 3 niko very hesitant ikifika 4 3.
Niweke tu 8 pm hapo. Mtu apumzike kidogo.
8 pm.
In fact,
Okay.
by phone
Mtu
Okay, ni kesho
apike.
unasema nini ya kesho? Discussion.
anasema kesho.
Yes,
Mchana
za kesho.
tupumzike.
Mchana
Mtu
tupumzike.
afanye shughuli zake kidogo kidogo.
Yes.
Hata tutafute njia ya kwenda Oro. Nisikia kuna tu
Lakini niambie Mbogwa Martin.
yes.
Unaona tukimalizana na Oros. Tusiseme 3 months ni mingi. 3 months ni kidogo.
Sana.
Kidogo sana.
Tukimalizana na hii nini? Tukimalizana na hii Oros. Hata hatuna group meetings za nini hatuna group meetings.
I totally agree. By the way, we should not raise our foot from the pedal.
Juu hata nikwambie ikifika end of September tuingie October kama hatujakuwa na bidii tuanze sasa tutaanza kustrain.
True.
Unaona ujaguza LPM ujaguza nini kichako inachanganyikiwa. Tukiingia mimi naomba tukiingia October nikaa tunafanya revolution hapa.
We should start it as early as September, October.
Nakwambia ni tukifika by the time tuingie October tushapitia kila kitu tuko fiti inakaa tunafanya elevation unaona as in tusiseme unajua kuna venye sasa inapitia na unit hatujaguza vizuri si ndio
kabisa
nataka tukifika nini October kwa duili tukifika October at least tukienda kwa conveyancing ni kujikumbusha tukikumbuka zile content at least mwalimu anaguzaguza unajua hata wenyewe wataanza kutuguide kufanya CLE tunakuja tunaendelea discussion yetu tukibuy idea zao.
No, very true. But what you're saying is 100%, and I like the fact that, and me, I'm so happy because now I have my study group until I do the last paper. So I am very happy because I was getting a bit worried.
There's another guy tulikuwa tunaongea na yeye. Alikuwa ananiambia about to form minister. Namwambia form study group si lazima mkue mbao kwa hiyo.
Yes.
Hata mkikuwa wawili ama watatu but it's committed. Kwa committed. Siku kuja tuachilie vita tusomee answer. Hata si research. No, 100%. And that's what I would like to what Shedik was saying, that we need to not start tackling after hiyo ni kuchukua the real exam questions. Tunachambua paper tunamuuliza until you're able to get to know, and then also we start predicting what are the possible questions that the CAD is likely to ask. What are these tricky issues that they could ask you? So that even if you have your honor, you have your but the main exam, those are 60 marks are many. Hata kuna nini mwingine alikuwa anaongea hapo kwa nini mwingine hapo sawa alikuwa anaelezea about CLE. Yaani yule jamaa alikuwa anasema unajua wase wengi utaingia pale CLE kama unajua CLE there is a way of approaching each and every question. There is a way of unajua watu wanakutest tu the real wanaona kama wewe ni practicing nini sasa. Unajua hapo ulikuwa unafunzwa kupractice. Sisi tulikuwa leo tulimalizana hapa hata CLE ndio wanaona wao hata marking wanakuanga strict tu mtu anaenda kupractice hapa nje.
Unaenda kupractice nini?
So you have to ukianza question lazima ukuwe na issues. Uanze na mafact issues kitu. Unajua kuna vitu zingine zina follow FIRAC, zingine zina probate. Tulikuwa tunaambiwa na nini inaanza na hai. Issue, fact, rules, sijui nini na conclusion. Mostly unapata zile mingi massive na nini zinafuata kama FIRAC hivyo. Unajua wewe utaenda kujaza tu swali kiama cha tu unaweza kuwa na nini na point but the way umeziarrange mtu anaona okay akona content but hajajipanga yani ana ile nini ana ile okay unajua pale ni kupeleka kitu into practical motion yani kitu as in you have the knowledge make it work. Sikukaa kama ulikuwa umeclam vitu.
True.
Okay, ndio maana ulikuwa unasikia mpaka nani ule madam sijui nasikianga anafunza probate nini yule Anastasia ama something like that. Anasema yeye the way she interpret nini section 335 of nini law of succession. Yeah, we relate na marriage act. The interpret with nini Odera ni very different. Amaji they interpret very different.
That's what I hear.
So yeye alikuwa anasema okay, sisi hatutaki answer. The correct answer. Okay, pursued ni elewa aje. Sawa, hivyo umeniambia unaelewa?
Yeah.
As in, sisi hatuko hapo kupata utuambie the correct answer direct. Hapana, convince me.
Yeah, true. No, I totally hear. So me, I think I'm happy that Victor and Chedwick were fast. Na sisi tunafuata huko the other week. Zidi kwa mwisho tulikuwa na Arnold. So lazima at least you shall tell us how we'll be on the chopping board first to tell us how we are gonna be.
In fact, sijui mbona mimi nafurahi kukua hivyo kwanza. I don't know why. Nafurahi hiyo.
I think it's bad.
Tena tu ukijificha bado Mr. Martin utakutwa tu bado. Yani
like the only thing I didn't want to do, I did not want to cut in the first 1 week. The first 1 week. For sure, that one I still feel I have a bit of grounds that I need to cover. That I need to be able to cover so that I can be able to get all the concepts. That's why you're seeing I'm very, very keen on the concepts. So that I'm able to get them right and get them right correctly. Yeah? But what I've seen, from what I've seen, there's 2 areas that you must get right. Once you get those 2 areas right, then the rest is very easy. The key concepts. So very good. Me, I'm happy, and I'm also happy to come towards the me at our Kineka the last day. Me, I don't mind whichever day they give me now. I'm okay.
By the way. Mimi najua one thing, acha niwaambie kitu moja. Na mimi naona tunaenda tukielewa. Unaona nimeonyesha cause outline ya LPM. Kuna kitu nimeidentify. Tunafanya kitu inaitwa evaluation. Sasa hii nikiwekea SOPEC rule, tulidiscuss SOPEC rules. Automatically ukiulizwa maswali za professional ethics huwezi anguka. But ukiulizwa vitu kama LPM kidogo kuna challenge. Kidogo unapata watu wana struggle. Sasa tukikava hii cause outline ya LPM utaona venye utakuwa na confidence in LPM. Leo tumeguza trial advocacy, Desmond na Faith Mwini. Hiyo hata ulizwe umefunga macho. Hizo vitu utaisahau. Unaona? So tuna counter the key areas in a procedural manner. Chedwick ameuliza swali ya conveyancing. Mimi mwenyewe leo nimepiga procedures za conveyancing experti. Hizi procedures unaniuliza partition na ni kitu nimeifanya practically. Unaniuliza subdivision, yani practically through teaching. Unaniuliza subdivision na ni kitu nimepitia leo automatically singeanguka hiyo swali.
I think and I believe you're going to. I can't wait to get to finish this KSL. Why, to be honest with you, you're amazing. We haven't been so much.
Unajua Mr. Martin hata wanasema mawakili ni kama inakuanga kupita by exam ndio the end goal. Juu once mawakili wengi wamepita by exam, the urge to learn inaishanga. Hiyo ndio the sad reality. Unapata sasa your attention imeshift to making money. So unasahau hata kupata time ya kustudy jurisprudence.
Kama mwingine hapa alikuwa ananiambia okay, ananiambia sasa ni practicing sahi. Ananiambia naendanga tu ni cloud ama ChatGPT anaweka sijui pleading nini ana edit. Nikamwambia hiyo ni uvivu. Ni lazy.
True.
Ananiambia hata but
anyway, good enough. Gentlemen, it is going to come to 2 in the morning. I think let's rest. Tomorrow we get a chance to go to church, to kumzike kidogo. We do 1, 2, 3, but we will not be moved. Then we get back to When are you submitting? You're submitting your project on Friday.
Yeah.
17 on Friday.
Even another.
Zetu ziko ready, imebakisha tu kuweka. Niulize swali moja. If mmefanya nini yenu online, if your discussion imekuwa online, is there any rule that says kama wewe ni wa online class you attach you attach attendance sheet? No, if ulikuwa online lakini mkafanya physical meetings.
Yes,
so mna sign physically, si ndio?
Yeah.
Sivyo ndo naambia my team. Sasa my team wana worry atatoa pia attendance sheets. Mr. Chebik.
Victor, fanyaji. On Monday from let's say 12 to 1 ama 2,